Good afternoon, everybody, and welcome to our monthly webinar with Osceola School District. My name is Soren Richardson, and with me today I have Christy. Christy, hi, welcome.
Hi, everybody.
Christy, it's a pleasure to have you. I saw you this morning. It's a pleasure to have you again. Can you tell us a little bit about your role within the school district?
Yes, I am the program specialist for transition here at the district, and I oversee the 18 to 21 programs and the project search programs here for Osceola School District.
Awesome. Thank you so much. Well, it's a pleasure to have you. So
Thanks.
today we are going to be talking about parent participation and procedural safeguard. This is in the series that we started about It's a Great IDEA. And we are going to be covering the last two parts of the series. This is a reschedule from January when we no, no, this is not what I need. Hang on. I'm trying to share my screen here. I'm trying to full screen. There we go. All right. I am recording. I am sharing. So yes, this is the last two in the series of the IDEA. And in January we had to cancel. So today we are rescheduling. So, as you may know, my name is Soren Richardson. I am the co-director here at PEN, Parent Education Network, and I'm also mom of a 9-year-old that happens to have Down syndrome. And he is the reason that I do this work, and share my lived experience with you. Real quick, we are a we would be I mean FND. We are a 501(c)(3) nonprofit organization. We are one of the few organizations that are funded under OSA, but that are written in IDEA, Part D. So all the grants that we get from the OSAP department makes that the services that we provide are always free. We are funded in part by the U.S. Department of Education and the U.S. Department of Health already, like I said. And we are your statewide parent training information center. And we also house the Family to Family Health Information Center. We were founded in 1985 by parents of children with disabilities, and we serve families that have children, young adults, toddlers from birth up to age 26 that have a disability or are at risk of having a disability. One of the things that makes FND unique is that majority of our board members, management staff, and all field staff, we are parents or caregivers of a person that has a disability. So we share that lived experience with you. A disclaimer, we are not attorneys, we're not doctors, we're not mental health professionals, we are not paid advocates. We do not attend IP meeting, even though we talk a lot about IDEA, and that's one of the things we're going to be doing today. We are sharing information, resources, and we support you navigate the special education here in Florida. None of the information that we share with you can be considered legal or medical advice. We use research-based information to create training in like this, and we encourage collaboration with schools and agencies. All right, so we have talked a lot about IDEA in the previous five workshops in this series already. So the purpose of IDEA, Individuals with Disabilities Education Act, have the roots in the past when children with disabilities were often excluded from schools. So the Congress had findings that they used, and these findings were that disability is a natural part of the human experience and in no way diminishes the right of individuals to participate in or contribute to society. So improving educational results for children with disability is essential element of our national policy of ensuring equality of opportunity, full participation, independent living, and economic self-sufficiency for individuals with disabilities. So that's our the findings that we have find so far. Now let's go look at our three of principles. So there were six principles. We have covered free appropriate public education, that was FAPE. We also covered appropriate evaluation, the IEP, least restrictive environment, and today we're going to be talking about parent participation and the procedure safeguard. Two of the six major principles of IDEA. So the evidence is clear and consistent. So when schools and families work together, student learning and outcome improve. And so do children's attitudes towards schools, their social skills and behavior, and the likelihood that they will take more challenging classes and pass them. And this is also the reason that here at FND we encourage collaboration with the school districts. And given the power that family involvement has to influence how our children achieve in school and in life, it is not surprising that the nation's special education law, which is the IDEA, strongly support parents' right to be involved in the special education their child receives. And IDEA specifically states almost 30 years of research and experience has demonstrated that the education of children with disabilities can be more effective by strengthening the role and responsibilities of parents and ensuring that families have meaningful opportunities to participate in education of their children at school and at home. This comes directly from IDEA. So one of the IDEA foundational principle is the right of parents to participate in educational decision making regarding their child with a disability. This law is very specific what school system must do to ensure that parents have the opportunity to participate if they choose to. So parents have the right to participate in meetings related to evaluations, identifications, and educational placement of their child. To participate in meetings related to the provision of a free appropriate public education. They are entitled to be member of any group that decides whether their child is a child with a disability and meets eligibility criteria for special education and related services. Also, they are entitled to be members of the team that develops, review, and revises the IEP for their child. The parent is 50% of the team. So even if it's one parent against the team, the not against, wrong word. If the parent and the school team, the parent is still counts for 50%. So also it's good to mention that if neither parents can attend the IEP meeting, the school must use other methods to ensure the participation, including individual or conference calls. Also, parents are entitled to be members of any group that make placements decision for their child. And they have the right to be involved at virtually every step along the way from their child's identification as possibly having a disability to the special education and related services he or she receives and where those will be provided. Now, you are not required to participate. However, it's encouraged, and that is your choice. So, what IDEA guarantees is that you are giving the opportunity to participate. And the rest, whether to participate, how much to participate, that is up to you as the parent. Parent notification. So when you have a meeting, we all get a notification, and that is what we call a prior written notice. And the short for that is the PWN, because we have an acronym for almost everything in special education. So prior written notice refers to messages that you will receive from the school system at specific time. At its core, prior written notice is meant to inform you as the parent as fully as possible about any actions the school system is proposing to take. Um, and it could be regarding your child's identification as a child with a disability, your child's evaluation, his or her educational placement, the provision of FAPE. It could be a numerous things. And then also the prior written notice includes notifying you of upcoming meetings far enough in advance to ensure that you have the opportunity to attend and schedule those meetings at a mutual agreed on time and place. So, the notice regarding the meeting that the school will provide you. So on that notice, you will see the purpose of the meeting, the time, location of the meeting. It will also indicate who will be attending that meeting, and it will let you know that you may invite individuals, whoever you want that has knowledge or special expertise of your child that can contribute to the meeting. Now, if your child is moving from early intervention services, so part C of IDEA, to school age services, including the pre-K, the notice the school sent you will also let you know that you, as the parent, may ask that part C services coordinator or representative may be invited to the initial IEP meeting. And in my case, when my child transitioned out of early steps to the pre-K, I did invite the my service coordinator from early steps because it was somebody that I felt comfortable with. So some meetings are not considered meetings that require school to give you prior written notice. So a couple of those meetings that do not require a PWN are informal or unscheduled conversations between school staff, between school system staff, conversations on issues such as a teaching methodology, lessons plan, or coordination of services, and of also the preparations and activities of school staff developing a proposal. So, a response to a parent's proposal that will be discussed at a later meeting. So these are gatherings, meetings that do not require a PWN. So the school system will need to provide parents with prior written notice in different occasions, specifically in these two. When they are proposing to initiate or change the identification, evaluation, or educational placement of your child, or the provision of FAPE to your child, or when they refuse to initiate, change the identification, evaluation, or educational placement of your child or the provision of aid to your child. So this means that the school system must give you prior written notice before it may take action or refuse to take action regarding these topics. Notice is also required regarding providing FAPE to your child. So that means that the school system must provide prior written notice at a reasonable time before it begins providing FAPE to your child. Also, refusing to provide FAPE or changes must include a notice. So this is how a prior written notice may look like. It's meant to, like I mentioned before, to give parents a full explanation of what a school system is proposing or refusing to do. So let's say they want to decrease speech therapy. They have to give you a prior written notice with a description of the action, an explanation why, a description of each evaluation procedure, assessment, data, where they're going to base that decision on, a statement that the parent has received the procedure safeguard, which we're going to talk about that, sources for parents to contact to find help to understand this provision, and an action of any other factors that are relevant in the decision making. Also, if they decide to increase speech therapy, you need to get a prior written notice with all the description on it so you can understand why there is more services being provided. So IDEA requires that prior written notice be written in language understandable to the general public and also provided in the native language of the parents or other mode of communication used by the parents unless it's clearly not feasible to do so. So if your native language is other than English and you understand better, because special education has more very specific terms, you have the right to request this in your native language. So if the native language or other mode of communication of the parent is not a written language, the school must take steps to ensure that the notice is translated, that the parents can understand the content of the notice, and then there is written evidence that these requirements have been met. So if the prior written notice has to do with your child's initial referral for evaluation, the school will actually include a description of the procedure safeguard. So that is automatically right in. And we are going to be talking about the procedure safeguard right in the second part of this workshop. Now, the school system will automatically provide you with this important decision of your rights under IDEA. Specifically, the law requires that the procedure safeguard notice be provided to you as parents only once a year and these other times. So, when your child is first referred for evaluation, or when you ask that your child be evaluated, when the school system receives the first due process hearing complaint in a school year, when the school system receives the first state complaint in a school year, if your child violates a code of student conduct and is subject to a disciplinary change of placement by the school, and when you ask the school to provide the procedure safeguard notice, okay? This is all instances where you're going to get a procedure safeguard. And at every IEP meeting, you're receiving a procedure safeguard as well. So on this slide, you can see one of the one pagers that we have available on parent right that we are going to be sharing on the small flyer. And this is you can get it digitally, but also we have them in hard copy. Now we are, let me see. we are going to be switching from parent participation to, we're going to talk about IDEA procedural safeguards right now. All right, so we're going to go back to the six major principles so we can see it in visually in one line. So now we are going to be talking about the six major principle. This is the procedure safeguard. And those are those, some school district gives them as a color paper, very difficult to read. Not my favorite reading pastime. Let's put it that way. So the federal law, the IDEA, says that as the parent of a child with a disability, you have certain procedural safeguards. And these are rules, what procedures the school and parents also must use in making decisions about the child's ESC services. So we are going to be exploring today on how and when to use them. So first of all, I want to say that the procedure safeguards are designed to make the ESC process fair for you and for the school, and to help make sure that your child receives a free, appropriate public education, FAPE. Procedure safeguards give parents and school a set of rules to help them work together. Okay, because dispute and disagreement is natural. It happens. But now we have tools to help solve problems and settle disagreements. So if you have good reason to believe that your child is not receiving a free appropriate public education, you may want to use the use make use of your rights, including the right to mediation, state complaint, and due process hearing. And these are all the ones that we are going to be talking about today. So you and your child, you have many rights, and to mention a few, are you have the right to FAPE, free appropriate public education, a complete fair individual evaluation, an IEP, an education in the least restrictive environment, and a yearly review of the student's progress, or the yearly IEP meeting. So here are three examples of procedural safeguards that are essentially important to you and your child with a disability. The right to have written notice, the right to participate, and the right to give, not give, or withdraw consent. Okay, so we just covered the prior written notice under parent participation, and this was whenever that the school proposes to make a change to your child's provisions of ESC services, placement, anything that has to do with on the IP, they need to provide you with a prior written notice. Also, we just covered the right to participate, right? So you have the right to be a part of the team. You are 50% of the IEP team, and you have the right to be part of the decision making of your child's special education. Now, for some actions, the school only has to let you know what they have decided to do or not to do to give you notice. However, they must have your written consent before they take the following actions. So, to conduct an individual evaluation of your child, for any evaluation, they need to have your consent and to provide ESC services for the first time. they need to have your written consent. And when they have your permission, it means you agree to let the school staff do something for your child. You're going to be asked to sign a form that says you agree to what the school is planning to do. Okay. And this is what we call consent. And you have several choices when the school asks you for consent. You may agree and then sign the form. You may ask for more information. You may ask for time to think about what is best for your child. And you may ask the school staff to change what they are planning. They will either make the change or decide that the change is not appropriate. So if the school staff refuses to do the change, they will let you know in a prior written notice. And you may decide not to give consent. Okay. Oh, wait, I wanted to mention that also. One, at the moment when you give consent for, let's say, to do an evaluation, and you thinking about it, and you decide that that's probably not the best evaluation, the best, you are have the right to withdraw, revoke your consent at any time. And also, after your, let's say you signed, you consented for your child to receive special education, then you have the right to consent to revoke or withdraw for your child to receive ESC services. You must do so in writing, okay? And this is necessary before the school district can stop providing EC services. So it has to be in writing. Okay. And then we have that from time to time, you and the school staff may disagree. Okay. Like I said, disagreement is natural. And some disagreement can be resolved easily, while others may take time and more effort to resolve. The first step in resolving problem is to make sure that everyone understands what the problem is. It is often best to ask for a meeting when you don't understand something or think that the school doesn't understand you. You Many times talking to the right person will help resolve the disagreement at the moment. So, people that you can contact, the line of contact. First, contact your teacher. Then, if that doesn't get resolved, you can contact the principal of the school. Then you can contact your IEP team. Then you can contact the ESC administrator in the local school district office. And then last, if it still is not being resolved, then you can contact the superintendent of the school district. If other problems come up, find out who has the power to make decisions about those problems and talk to that person. Taking a complaint to someone who cannot make decision sometimes is not, it's just not efficient usage of your time, either for you or for your child. Now, let's say that you and the school district are still not able to agree about what is needed for your child. Then you can use your procedure safeguard. You can decide to ask for mediation, file a state complaint, or ask for a due process hearing. And these are all the purpose of all these tools are to solve problem. They are designed to make sure that children with disabilities receive the free appropriate public education, and they are not designed to punish the school or anyone else. That is very important to mention. All right, let's look first at mediation. So during a mediation session, A trained and impartial mediator will help you in the school district to resolve your disagreement about, it could be about identification, evaluation, placement, you name it. And you may ask for a mediation at any time, even at the same time that you are filing a state complaint or you have asked for a due process hearing. For mediation to occur, both of you and the school district must agree. So we must have mutual agreement to participate in the mediation. And then after you and the school district send a request for the mediation to the Florida Department of Education, they will assign a mediator and schedule a mediation session. And these sessions usually they are about 3 to 6 hours. And what happened and any agreements that are being made during a mediation session are confidential. And the purpose of mediation is not for one side to win, but for both sides to come to agreements. The mediation session will give you and the school district a chance to talk about the problem, explain point of views, and come to agreement that are best for the student. And the mediator will not decide how to solve the problem. The mediator will help you and the school district staff to come with ideas to solve the problem. Okay. Now, a couple of advantages to mediation is that mediation services are free. Disagreements are typically solved more quickly through mediation. And mediation may improve your working relationship with the people in the school and the school district. Okay. Now let's talk about formal state complaint. Parents may try to solve problems by filing a formal state complaint with the Florida Department of Education. You should only file a state complaint with the Bureau of Exceptional Education and Student Services, BEAS, if you believe that the school district has violated a requirement of IDEA or state laws and rules related to education of students with disabilities. Problems like bullying, discrimination, or the behavior of staff do not count as violation of IDEA or state law relating to students with disabilities. However, staff can help you locate the correct area within FDOE to file a complaint of these issues. You are encouraged to call the FDOE before filing a complaint. The FDOE staff may encourage you to try mediation or other methods of solving the problem, or they may contact the district on your behalf to help resolve the issue. However, if you decide to file a formal written complaint, your complaint must contain the next three points. It must describe how the school district has violated a requirement of IDEA or another law. Explain the fact of the situation as you understand them, and be about a violation of law that occurred no more than 1 year before you filed complaint. So if it has been more than a year, you cannot file a state complaint. During the complaint process, FDOE will ask you to explain your complaint over the phone or in writing. And the FDOE will investigate to find out if the school district has violated a law or rule. Okay. And then within 60 days after the date your complaint is received, FDOE will issue a written decision. And this decision will list the findings of facts, list of laws or rules that were to be followed, state the FDOE decision, and also state what the district must do to correct the problem. If there is also a due processing hearing about the same issue in the state complaint, then the state complaint will be set aside to allow the issue to be decided through the due process hearing. Okay. And then if the issue is already being decided through a due process hearing, then the decision cannot be reconsidered through a complaint process. So there is guidelines for that. Now, the right to due process hearing is given to parents and school district as a way to help them resolve disagreements about a child's evaluation, eligibility, placement services, or an IEP. Okay. An administrative law judge runs the due process hearing. So in our state here in Florida, the law judge works for the Division of Administration Hearings, DOAH. The law judge cannot know the student or be a friend or relatives of the family. And at the hearing, the administrative law judge will listen to your explain what you want and why. They will look at the school district records and explain their point of view. They will listen to people you choose to help explain your point of view and ask questions. Now, after the hearing, this administrative law judge will make decision based on the law on rules. So the due process hearing is a formal procedure, as in a court, right? So certain rules apply. You have the right to have a lawyer or other person to help you. A lawyer will represent the school district. You and the school district may have witnesses to help explain things to the administrative law judge, and you and the school district may show evidence to the administrative law judge. It may take up to 45 days or longer in some cases from the time you ask for a hearing to actually have the hearing and to get a decision from the administrative law judge. So during this time, right, your child will stay in the present placement, which we call stay put, and will keep receiving the services in their IEP if they have one. So while you are waiting for the hearing, you will be asked to try to work things out in a meeting called the resolution session. And if you and the school district agree, you can try mediation instead. And you can also ask for mediation during the process hearing and any other time. And then if mediation doesn't work, you still have a due process hearing. Let's talk about the independent education evaluation. That's also part of the procedure safeguard. So at any time, you can pay to have your child privately tested and bring the results of that testing to an eligibility staffing or IEP meeting. The team will consider the information you have provided, but they may choose not to act on the information for a variety of reasons, right? So if the school already done an individual education evaluation of your child and you disagree with the results of the evaluation because you do not recognize your child in the results, you can ask the district to pay for an individual independent evaluation educational evaluation, IEE. An IEE is an evaluation done by a person who does not work for the school system. Okay, so you may ask for an IEP if you have good reason to believe that the school's evaluation of your child is not complete, not correct, or not fair. So when you ask for an IEE, you are really asking for a second opinion, right? So before asking for an IEE, please study the school's evaluation carefully. Be able to explain why you think the school's evaluation is not correct, not complete, or not fair. Ask people at the school to talk to you about the evaluation. They may be able to clear up your concerns. And also talk to the ESC administrator in your local school district office. If you decide to ask the district to pay for an IEE, you should do two things. One is call the ESC administrator and let them know about your decision and ask for the IEE in writing. Okay. And some school districts have a form that you can use. An IEE can cost a lot of money. So it's very important that you know who will pay for the IEE before it's actually done. So if you and the school district cannot agree on who will pay for the IEE, mediation or a due process hearing may be needed. Okay. Now, parents and teacher know it is important for schools to be safe and orderly, okay? Since discipline problems make it hard to teach for teachers to teach and for children to learn, all teachers, no matter of disability, must obey school rules. And sometimes when a student does not follow the rule, it results in their suspension or expulsion. Now, children with disabilities may have the right to receive ESC services even if they have been removed from the placement for disciplinary reasons. So, the following factors determine when a child with a disability may be removed from their current placement for disciplinary reasons and when they must continue to receive services. That is, how long the child's removed from school, whether the child's behavior is a manifestation of the child's disability, whether the misbehavior involved weapons or illegal substances, or whether there's a good chance of serious bodily injury to others, and whether the removal is a change in placement. Okay. So a child with a disability may be removed from the current placement for a disciplinary reason for up to 10 days in a school year, and for more days for separate acts of misconduct as long as the removal do not form a pattern. However, if a child with a disability is removed from school for more than 10 days during a school year, the child must continue to receive services that will help them make progress in the general curriculum and towards their annual goals on the IEP. So on the chart, on the next page that we're going to be showing, describes what a school or district must do when a child with a disability is removed from school for disciplinary reasons. Okay, so here we can see on the chart what they can do, and they going to have to do a manifestation of a meeting, a manifestation determination meeting. I always get those confused. Okay, so schools keep many written records about the students with disabilities. And these records contain personal, private information about a child. So the Family Education Right and Privacy Act, FERPA, and other law gives you many rights relating to school records. And these rights include the right to see your child's record. You have the right to have school records kept confidential. You have the right to ask that school records be changed, and the right to have a hearing about school records. If you believe that the school district has violated school records law, you may file a complaint with the Family Policy Compliance Office of the United States Department of Education, and we have the address for you if you need that. You have the right to see and read any record the school keeps on your child. You may also have someone else, a friend, a relative, advisor, look at the records if you wish so. So if you ask, the school staff must tell you what records they have on your child. They must also tell you where the records are kept. If you ask to see your child's record, the school must show you the records about without any unnecessary delay. And before any meeting, and before any meeting, they about your child's IEP or a due process hearing. And in any case, the school must show you the records within 30 days of you asking to see them. The school under the FERPA law cannot destroy any records you ask to see before you see them, and you may ask to have a copy of any record kept by the school. There may be a charge for copying, but you have the right to have a copy. So, school records that include your child's name, birth, date, address of Social Security must be kept confidential. And these records can only be shown or sent to certain people under certain conditions, such as people at a school or the school district who have a good reason to see them, organizations doing educational research, organizations to which your child has applied for educational financial aid, um, and so on. So if you see something in the school records that you think is unfair to your child, you can ask to have the record change. You need to explain why you think there is a problem with the record. And you can ask to have something added to the record also, taken out of the record, change in the record. And you should ask for any of these actions in writing. And the school staff will either do what you have asked or send you a letter telling you they refuse to make that change. And they will also tell you that you have the right to a hearing. All right. And when you have the right to a hearing, if the school refuses to make changes to the records, this is not a due process hearing. Okay, it's different. Now, on this page, you can see a visual of the procedural safeguards that we have here at FND. And here you also can see the communication ladder that we have talked about during the presentation. You can also see all the programs that we have under FND. And I wanted to share with you that if you have any dispute, any disagreement, uh, always think what is best for your child. Here at FND, we are all trained as facilitators by Key to Ed, which is the organization that train all the district staff. And we do not attend those meetings, but we are trained as facilitators, so we understand the process and we can share that with families so they know what is going to happen. Dispute is natural, but we follow the cadre, which is the National Institute for Dispute Resolution. We follow the cadre continuum, which is in this presentation, it's where we have a dialogue, and then we can go to a state complaint, mediation, state complaint, and due process if needed. If you want to talk about it, please feel free to reach out to us here at FND or to your teacher, your principal, your ESC representative, or your IEP team. So with that, it concludes our presentation today with our IDEA series. I thank you so much for being here, and Christy, thank you so much for joining us. And we will see you all next week on the 12th for our workshop. I believe it's transition to kindergarten. I wish you all a good rest of your day.